turn it over to you, Terry Kaye from TSK. I just made a rhyme. Take it away.
Yeah, you did.
Another rhyme.
Okay, Jeff, thank you. We'd like to welcome everybody to our second evening certification program for board members. Last night we did the condo certification, and I'd like to welcome Emily and thank her for doing this for us. We don't have a lot to talk about tonight that Emily won't, but I wanted to just mention that you see up on the screen our service provider members who are online with us on our website, and we'd like to welcome them. And you can get online and get any information, see their little videos on our website, and get any information about them that you'd like to, because they support these programs, and it's interesting to do that. So Emily, she's been with KBR for quite a while, and she's very well versed in this area, and so we'd like to let her get going and give you as much time as we can with her. So thanks, Emily, and why don't you just introduce yourself?
Thanks, Terry. It is funny, the Terry Kaye and Kaye Bender Rembaum, and no relation, but popular name, I guess. My name's Emily Gannon. I am an attorney here at Kaye Bender, as Terry said. I've been here over 9 years. I think it's 9.5, something like that. I've been practicing since 2005. I passed the bar in the association field for the last 11 or 12 years, I'd say. Did some other stuff before that, but now I'm here. And so all our firm does is association work. So community associations, HOAs, co-ops, condos. Tonight's just about HOAs, and we run the gamut, all of the services you could possibly need, amendments, contracts, helping you out with your elections, all that good stuff. Questions about your docs, we do all of that. So we'll dive in. Terry, is there anything else we need to cover before we get into it?
Nope, we're good. I think Jeff's covered most of the housekeeping. So I think you're going to take questions at the end. You don't want to be the interruption.
Yeah, so guys, I think it'll just be easier if everyone's okay with it. And I say that, but realistically, we've already made the decision. So too bad if you're not. We're going to do questions at the end. And I think that'll just be better to get through everything. If I see something that glaringly looks like I confused you, if I misstated something and you call me out on it, I'll stop. But other than that, try and hold your questions till the end. We go through the outline, and Jeff, was everybody sent an outline? We're going to go through it. I'm going to share my screen as well, and I'll read through it and add some commentary as we do it. I won't just literally read it verbatim because you'd be super, super bored.
Yeah,
but,
and the outline was in that reminder email that went out an hour ago, but I'll put it into the chat area in just a couple of seconds here. And okay. I see a question. This is for you're welcome to stay if you're part of a condominium board, but this is for the HOA certification. Jay William, I just see the question in there, but you're welcome to stay. But again, this is for HOA. You will not be getting a certificate for condo with this course.
Right.
Thank you. Important question there.
And one more question, Emily. Yeah. How long is this? Because when we do it live, it's about 3 hours. So how long will it be today?
This course is 2 hours. So okay. Bonus. Usually when we do sort of the joint one with the co-on or the condo as well, then we'll extend it to the 3, but 2 hours, and we should be all set. Again, right. as I think Jeff and Terry both said, keep in mind, this is a sort of a basics HOA 101 course. So we're not getting into, really the nitty gritty details of anything just yet. And if you guys have questions about your particular associations, please, keep your questions general. I can't help you if you're being too specific, because I can't give you legal advice here. It's just for general informational purposes and education. So keep that in mind. A question of, hey, what do we do if there's a vacancy on the board is a little different than, so on my board, we have 3 people and there's a guy named John and he doesn't like to come to meetings. There's a difference there. See the difference? So keep it general and we'll address those. If you're too specific, I'm not going to be able to help you. I'd love to help you. You know, obviously you can contact me outside of this. And we'll help you any way we can. But all right, shall we dive in?
Let's
Let's see.
dive.
All right, so here is our outline. This is our little intro page here. First section is going to be operations. Now, like I said, if you guys want to follow along, you can make some notes. Otherwise, I'm just going to sort of talk you through it. I won't read it line by line because again,
Emily, real
that would-
quick, you can go ahead and share the screen. We don't have the screen share yet.
Oh, you don't have it yet? Hold on, where'd it go? There we go. Can you see it now?
Yes, we can.
All right.
Yes, perfect.
Okay. So first things first, operations, basic, let's stick with that. When you guys are on the board, you have a fiduciary duty. You are supposed to be serving your community. You're not supposed to be, you know, necessarily looking out for your own best interest, but what's best for the community. Keep that in mind as we go through this. Now, the association is responsible for operating the affairs of the community, and then being on the board, those decisions for the association are made by the board members. Now, a couple of statutes we're going to talk about today. Chapter 720 is really the big one for HOAs. You probably hear Condominium Act a lot, and that's Chapter 718. They are slightly different. I know sometimes 720 and 718 can be similar, but for our purposes today, for HOA world, we're talking about Chapter 720 and 607, 617 of the Florida statutes. Sometimes those come up, but primarily it's going to be 720. Chapter 617 is the not-for-profit statute. Sometimes we can fall back on some things in there as well, but most of your stuff is going to be under 720. Generally, again, keep in mind on a board, you're running a corporation. That's why that 617 not-for-profit statute might come into play. You have the power to sue, be sued, purchase property, sell, mortgage property, incur liabilities, all of that. All of the powers necessary to effect and operate a corporation. These things are going to be done by the board primarily. Now, there are some emergency powers. This is a sort of a hot topic, obviously, over the last year or so in the statute. And just recently, there were some changes clarifying that your emergency powers are now going to apply when essentially in a pandemic. So we can get into that a little bit more later if we need to, but maintenance and improvements, let's look at this. So first thing I'm going to tell you, and actually let me backtrack just a little bit. When we go through this, I'm going to be talking about your governing documents. And that's the phrase that just, you'll see it right there, governing documents, sometimes governing docs if I'm using a shortcut, sorry in advance. But typically that means your declaration of covenants and restrictions, your articles of incorporation, your bylaws, and then you also have some rules, regulations maybe, or some architectural guidelines, policies, some other things that might come into play, in addition to the statutes that we're following. Now, keep in mind that governing documents was a term that was recently modified as well, just in this new session here. It used to include rules and regulations, which in theory sounded great, but the legislature realized they goofed a little bit, because by putting rules and regulations in there, when you look at the other part of the statute, whenever you amend your governing documents, they have to be amended in a certain way and they have to be recorded in the public records. By making rules and regulations part of the governing documents, essentially it meant now you have to amend, when you amend them or when you adopt new ones, you have to record them, you have to do it in that certain way. And a lot of communities don't have the rules and regulations recorded, and that was okay prior to this little glitch they threw in a couple of years ago. So now that has been changed. The rules and regulations are no longer officially part of the governing documents under your statute, but for our purposes, they still will come into play, and you may still be, obviously they're still important, your rules and regulations. And when we're talking about your governing documents, there is also a hierarchy. If there's a conflict, your declaration is going to control, then the articles of incorporation, then the bylaws, and then your rules and regulations would come into play. That's the order there. I like to joke because one of my colleagues uses this expression that apparently was from an old campaign, and I don't know what it is because I don't recall, but it was before my time. He says, if you need a little shortcut to remember, it's a little dab will do ya. DAB, Declaration, Articles, Bylaws. Hopefully you guys get that reference, or someone does. I don't know. All right. Now, and we also will run into questions sometimes of which one's going to control the statute or our governing documents. And that's a tricky answer as well. And unfortunately, I can't really give you a clear cut answer. Sometimes the governing documents are going to control, sometimes the statute's going to control. If you have any question, you need to talk to your attorneys. You need to see what the particular issue is there, because it will depend. Now, this first question, maintenance, seems simple enough. This is something that will be completely controlled by your governing documents. Look at your declaration. If you have any question of who maintains what, that's in your governing documents. Now, generally for HOAs, it's pretty simple. Generally, the association takes care of the common areas. You might have a clubhouse, you might have a pool, you might take care of the roads, you might not, you might have a guardhouse. You might have tennis courts, whatever it is. And typically the owners then take care of their individual lots. Again, we're going sort of simple HOA here. Now, you might be in a villa home. You might be in a townhome that is actually an HOA as well. So that might get a little more complicated. A question of who takes care of a roof of a townhouse gets a little tricky, or, a party wall, or maybe even the landscaping. But typically for HOAs, the owner takes care of the lot, the association takes care of the common areas. And again, if there's any question, look at the governing documents. They will tell you what the answer is. Now, another question that comes up in the world of maintenance and alterations, I suppose, is whether or not there's a material alteration. Do we need membership vote? Is that something that the board could decide on its own? And again, you're going to need to look at your governing documents. Most HOAs, there may not be any language. You may not need a membership vote. If you have a question about what a material alteration is, and I will read to you verbatim, because I don't even want to try and shortcut it here. And this was from a condominium case, and I'll tell you about the background of that in a minute. But essentially, if there's a question of what a material alteration is, and that could be something like, we want to rip down the tennis court and put in a pickleball court instead. Or we want to, it's something as simple as, hey, we want to paint the clubhouse. Is that a material alteration? So the question here, or the definition we're stuck with here, is to palpably or perceptively vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. That's a nice crystal clear definition, right, guys? Now, it gets a little tricky. So like I said, if there's a question about whether something's a material alteration or not, talk to your attorneys. And if it is, then the question becomes, okay, it's a material alteration. Can the board approve it, or do we need membership approval? And again, that answer is going to be in your governing documents as well. It may just be a board decision, or you may have language, something along the lines of, if you're going to put in a capital improvement that's going to cost over X% of the budget, it requires membership approval. So look at your governing documents, see what the answer is there. Now, there is an exception. And again, this was that condominium case, or this is an important condominium case about a seawall. So some time ago, there was a condominium located on water, and the seawall was essentially crumbling, needed to be repaired. Now, board figured, okay, great, we got to do the repair. We do the repair, and it required a special assessment because they didn't have the money for it. And some owner challenged it. Long story short, under the documents, they were supposed to have gotten a vote, but they didn't, because they thought they needed to do this repair. They didn't get the vote in time, or they didn't try and get a vote. So ultimately, the result was, even though in that case, the governing documents required a vote of the membership, because it was necessary maintenance to the common elements in that case, it was okay that the board went ahead and did it, and they didn't get the vote. And actually, the court went one step further and said the board should have gone ahead and done that repair, because they were responsible to maintain the common elements, and that work needed to be done. Experts had confirmed it wasn't something they just, the board came up with on their own. They had the support of an expert to say this is necessary maintenance to the common elements that must be done. Now, I caution you, don't use that as sort of your fallback. Hey, this was necessary maintenance, so we did it even though we didn't get our vote. It has to really be necessary maintenance. So keep that in mind. All right. Right of access to dwellings. This is one that, again, if you're in a townhome or a villa home, that might apply to you. If you're in a, typical sort of HOA, odds are you probably don't have the right to access any dwellings. It's not automatic. In the condominium world, it is. There is something in the statute that a board could access a condominium unit, but for HOAs, it's a little different. You'd have to look and see if there's something in your governing documents. We'll get into insurance. So essentially, the association has to maintain adequate insurance to cover the common areas. And if there's property that's damaged, a part of the common areas, that's again on the association to take care of that. Now, and that is only if it's through an insurable event, if we're talking about insurance here. So an insurable event is a casualty loss, a sudden unforeseen event, maybe a hurricane, maybe a bad storm, something along those lines. Let's see. In addition, here we go. In addition, you guys should have directors and officers insurance, or D&O insurance as we call it. That's going to cover the acts of the directors and officers. If somebody alleges that, the board did something improper or one of the directors did something that was improper, that insurance policy would kick in. Most likely you do have it. We also say, look at your flood insurance. If your community is located in a flood zone, you should have flood insurance as well. Now, promulgating rules and regulations. Okay, so we referenced rules a little bit before, and we'll get into this now. So typically the board is authorized to adopt some rules. Now, question is going to be, when we're talking about enforceability of rules, there's essentially a three-pronged test. Do you have the authority to adopt the rule? That's number one. Number two, does it conflict with anything else in the governing documents, a restriction that you already have in the declaration, for example? And then number three, is it reasonable? Now, so again, the way we've worded it here, the board has the responsibility to promulgate reasonable rules and regulations. And typically you want to look and make sure if that's just as to common area use, your clubhouse rules, that type of thing, or if that also concerns lot use, because you may want to adopt some rules regarding lot use as well. That would be in your governing documents. You need to look and check and make sure that authority is in there if you want to adopt some rules. And sometimes the other thing is you want to make sure you have the option to adopt rules without board approval, because there may be, or without membership approval, sorry. Sometimes, rarely, but on occasion, I've seen some documents that say that the board could adopt a rule, but the membership has the authority to veto the rule at the next meeting, or must or can confirm the rule at the next meeting, or something like that. So you may run into issues if you're talking about a board made rule. If you have that membership component, you want to look at that too and see if this is something that the board could do on its own, or whether the membership needs to get involved. So that's step one. Do you have the authority? What authority do you have to adopt rules? Now, step two is going to be, like I said, that second prong is whether or not it conflicts with other language in your governing documents. And really what we mean by that is if there's another restriction in there and it conflicts. If you're adopting a rule that expands on a restriction maybe that you already have in the declaration, then that rule would probably be fine. If you already have a rule that says no trucks can be parked in the driveway overnight, and then you want to adopt a rule that says truck means a vehicle that has this, that's this size, this weight, this tonnage, whatever it is. So that way you've clarified what that provision in your deck was. That makes sense. That works together. If you do not have any restriction in your declaration on this one topic, and you try to adopt rules to now restrict that same thing. So in this hypothetical, perhaps there are no vehicle rules, no restrictions in your governing documents about trucks or vehicles or commercial vehicles, no mention of a vehicle, no mention of automobiles. Your declaration says nothing about what could be parked in the driveways. And the board decides on its own, hey, we want to adopt some rules saying you can't park your truck there overnight. Well, you might run into a problem because now the presumption is that is unrestricted. You could park whatever vehicle because there's nothing in your declaration. If you adopt a board-made rule that now says you can only park X vehicles, or you can't park Y types of vehicles, now potentially that's a conflict. So you need to look at that very carefully too. That's what usually it gets a little tricky for a lot of boards, where they in their minds think we can adopt rules so we can put these restrictions in place. Lots of communities have rules about vehicles and things like that, but make sure you have something in your declaration too that you can tie that to. Otherwise, it might be considered a conflict and your rule might not be enforceable. The way around that, by the way, it doesn't mean all is lost. If you really wanted to adopt vehicle restrictions and essentially we told you, hey, that rule might not be enforceable, the way you would go about it is amending your declaration, which then would require a membership vote. Now, if you are considering a board-made rule, and the third prong, like I said, was the rule has to be reasonable. So hopefully you don't come up with anything too crazy. Typically, rules are pretty reasonable. If you are going to be considering adopting a rule, you need 14-day notice of the board meeting where that rule is going to be considered, if it's a rule that has to do with lot use. So this is one of those weird trivia points. This is the one exception, or they're going to be two. This is one of the exceptions where 14-day notice for a board meeting might be required. Typically, most people know board meetings, 48-hour notice, and we'll get into those in about a second, but this is going to be one of the exceptions. If you're considering a rule that deals with lot use, it's a 14-day notice for that board meeting. All right. Let's see. Now, covenant enforceability, this sort of rolls right into this topic. Now, like I said, you might be adopting or considering some rules that restrict vehicles. You may also have other covenants that might be in your declaration as well. And we always say, you know, with covenant enforceability or with covenants, a covenant is a promise, essentially. When you bought in your community, hopefully you realized it was a community that had restrictions. And that's probably why you wanted to live there, because all of the homes look nice. You have a gate. You understand you pay money for those things. All of that sounds nice. No one's house is, you know, painted purple and pink stripes or something, you know, crazy. And that's the exchange you've made. I promise that I won't paint my house purple and pink striped because I want to fit in and I understand these are the restrictions we have in our community here. So that is the same thing. Now, as a board member, the association is responsible to enforce these covenants and these restrictions and the governing documents. So now this is where your promise also comes into play as a board member. I'm on the board. I understand it's my job as a board member that we have to enforce these things. The association has to enforce those same restrictions the same way, you know, John Smith moved in and he promised not to paint his house pink and purple. Well, now we have to make sure John Smith doesn't paint his house pink and purple. So we like to tell you, you have to uniformly enforce these governing documents. The other part of that is, even though it's not written here, timely enforce your governing documents. So those are two key words, uniformly and timely enforce your governing documents and the covenants and restrictions. And I'll explain why. If you don't, then it may result in essentially a waiver or an affirmative defense you hear all the time, selective enforcement. I hate to even say it, but you do hear it all the time and for a reason. Waiver and selective enforcement are affirmative defenses that will come up if you're not properly enforcing your governing documents, which means ultimately, you know, again, you might have an owner that we'll keep the trucks as our running example right now. Let's say there's no question you've had a restriction in your governing documents in the declaration since the dawn of time that no trucks can be parked in the driveways overnight. They must be parked in the garage or whatever it may be. That's in your declaration. There's a rule clarifying overnight means between the hours of, you know, midnight and 5 a.m. or whatever it is. So crystal clear, no trucks can be parked overnight in the driveway. Now, maybe another board, or in the past, the board sort of relaxed and they didn't really, we don't want to be one of those. We don't want to be condo commandos. We don't want to be that kind of community. So they let some trucks come in. People park their trucks in driveways overnight all the time. no one's really said anything. Then maybe you come to this lovely class, you realize, wait a minute, I'm new to the board, but I see a problem here. We're supposed to be enforcing our rules and we're supposed to be enforcing our covenants and restrictions, and we're not doing it. My community is letting these people essentially have violations. What do? I got to tell the board. And then maybe you try and send a note to Mr. Smith and you say, Mr. Smith, can't park your truck overnight in the driveway. It has to go in the garage. And Mr. Smith is going to say to you, I've had this truck here for years. I've parked it in the driveway every single night, and you've never told me I couldn't, never been a problem before. Too bad, you've now waived your ability to enforce this against me. Now, he may be right. That could be something he could raise in front of the judge, and a judge might agree with him. Too bad, it's been too long. You guys knew that your restriction was being violated and you didn't enforce it. So you've waived association, board, you've waived the ability to enforce that restriction. Another one is selective enforcement. So maybe you say, John Smith has had that truck for years. Okay, we get it. He's the only one. We'll just let that go. But this new guy just moved in, and Mr. Jones, and he has a truck and he's parking it in the driveway. And this is new. So we don't have a waiver problem. We'll send him a letter and we'll say, hey, Mr. Jones, can't have your truck parked in the driveway overnight. And Mr. Jones might respond to you and say, well, wait a minute. You let Mr. Smith park his truck in the driveway overnight. You can't enforce against me if you're not going to enforce against him. That's selective enforcement. And again, he could be right, and your judge could agree with you if you tried to pursue that further. So waiver and selective enforcement, that's what we want to be careful about. We want to make sure you're timely and uniformly enforcing your restrictions. Now, something that we don't have in here, but I want to bring it to your attention anyway. If you have not properly enforced restrictions and covenants, and maybe you say, well, we already recognize we might have a problem with waiver. We might have a problem with selective enforcement. How do we clean it up? What do we do? How do we fix this? There is a solution, possible solution. So we call it republication. So you would essentially, the board would get together, decide that we're going to start enforcing this restriction, send out a memo to everybody. Hey, as of, and you pick a date, October 1st, we will start enforcing this. If you are currently in violation of X restriction, you would essentially be grandfathered in. We'll give you an opportunity to register your violation with us, and you're grandfathered in. And then after that date, any new violations or any violations that didn't register with us are going to be treated as new violations, and we can enforce them. And we've cleaned up the problem, if you will. Now, this comes into play sometimes and less in HOAs, but more often in condos. Maybe you have a pet restriction like that, and little Fluffy passes away, and then someone says, well, I was grandfathered in. Well, Fluffy 1 was grandfathered in. That was the violation. But Fluffy 2.0 is a new violation. That Fluffy 2.0 is not grandfathered in. Same thing if your neighbor gets a different truck and he goes from a F-150 to a 2022 F-350. I don't know a lot about trucks. I know those are different. And those are different trucks. If you get one grandfathered in, doesn't mean you get to be grandfathered in for the same violation forever. It's just that one particular violation that gets grandfathered in. Now, these covenants also include architectural standards, age restrictions, pet restrictions, like I said, guest restrictions, parking. Those are the big ones. These are the things that, for the most part, these types of restrictions will be outlined in your declaration. For you guys, it's typically something along the lines of a declaration of covenants and restrictions, or declaration of restrictions and easements, declaration of covenants, some variation of that. These restrictions will be outlined in your declaration. Now, if you do have somebody who's in violation, and we're not running into any issues with waiver or enforcement or selective enforcement or any of that. So what do? First things first, you probably have a management company. Typically, they'll probably send a nice, polite little reminder. Hey, Mr. Jones, maybe you didn't realize that, you can't park your truck overnight, or you can't have a commercial vehicle in our community, or you can't have, 4 dogs in our community, pursuant to whatever it is. Article 10 of our declaration, please make sure you correct the violation. You send a written notice, give them a chance to come into compliance, a reasonable opportunity. We always get the question, how much time do I have to give them? It really, there's no clear-cut answer. It's reasonable. Maybe you send them another notice if they don't comply in that same, in the next time period. Then you turn it over maybe to your attorneys, let them send a slightly more, hopefully more intimidating letter, and give them a chance again to come into compliance and fix whatever that violation is. And so again, be reasonable about your timeframes. If you're talking about, you know, cutting your grass, 10 days, probably fine. If you're talking about painting your house or pressure washing the roof, 10 days might not be a reasonable amount of time. They might need more time to get that done. Now we go into sort of what steps you could take if you still have these violations, you've sent out a notice and the owner either just refuses to do it or they ignore you altogether. What could you do? You have a couple different tools in your arsenal. The first is you could adopt a fine. You could fine this person for this violation. Now, statute says you have the authority to fine. Does not have to be in your governing documents. You can do it pursuant to the statute. Now, it can exceed $100 per violation, but it can be levied on the basis of a continuing violation up to $1,000 per violation. And then you need to look at your governing documents. Your governing documents might actually let you go above that. And if they do, then you can actually go higher than the $1,000. So that may be something, if you're considering amendments or if you're looking at your governing documents, look at that and make sure you bring your governing documents up to the maximum for your, if you wanted to, for the fines. You can go, but then you'd be able to go above it. If you can't, and you're limited to $1,000 per violation, and this is the other part of this that you might want to consider amending, you can't lien for a fine unless that authority is also in your governing documents, and it has to be a fine of $1,000 or more. So again, look at your governing documents and consider adopting an amendment, proposing an amendment that addresses that if fining is the way you want to go. Now, fining is sometimes not the most, we'll say, not the easiest way to go about getting compliance. Oftentimes we hear there are owners who will say, go ahead and fine me. I don't care. I'll pay you the fine, or I'm still not going to fix it. You fined me and you can't lien for it anyway. Stick it on my ledger. I don't care. I'm not going anywhere. Still not going to fix whatever the violation is. Too bad. And that does happen sometimes, unfortunately. But again, you can put it on their ledger, even if you can't lien for it. It can come up if there's an estoppel, if they're trying to refinance, if they try and sell their home, you may be able to collect it that way. And again, ultimately though, you may collect the fine, but maybe the actual violation hasn't been fixed. So keep that in mind. Now, for a hearing, the other thing is you have to make sure you adopt your fine properly. And that is tricky. The first thing is the association has to provide notice. They have to give the violator the chance to come before a hearing or come before a committee and have a hearing on the fine. The board adopts the fine first, essentially saying, hey, we have, photos, we have reports of this violation, supporting, $100 per violation on a continuing basis up to $1,000. We want to impose a fine of $1,000, presents it to the hearing committee. The committee, and I will read this too, make sure I don't forget somebody. The committee has to be at least 3 members that are appointed by the board. They cannot be officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. So that does cross a lot of people off your list. And a lot of people don't want to serve on the fining committee because no one wants to be the bad guy and tell their neighbor that they have to pay the association. So again, it can be tricky. And if at that hearing, the committee essentially decides they don't want to adopt the fine, or they don't want to impose the fine, and they don't approve the fine that the board adopted, then it's not going to be imposed. And they can't, this is important too, they can't negotiate. You can't, the board can't say, here's our documentation, here's support of the violation, here was $100 per day up to $1,000. So we think it's $1,000 fine. The committee can't say, well, it's a really nice guy, he's new to the community. $1,000 is a lot of money. What if we just fine him like $200? Can't do that. Committee is yay or nay, essentially. Now, suspension of use rights or voting rights. The board can do this on its own if the rights of the owner, or to suspend the rights of the owner to use parts of the common area, if that owner is more than 90 days delinquent in a monetary obligation due to the association. Now, that would be essentially, turning off a clicker or a transponder, or if you have a key card maybe to the clubhouse or to the gym or to the pool or something like that. If you have a clicker, transponder, those are usually the ways you would do it. You could turn that off, and you have to give them notice that you've suspended their use rights and voting rights. You can't keep them out of the community altogether. You could turn off the clicker and the transponder so that, now Mr. Smith has to stop at the gate and talk to the guard every time he comes in, as opposed to just click and flying through the owner lane. And that will annoy people. Let me tell you, I used to do some foreclosure work, and we would have owners that would call, and as soon as you suspend their use rights and turn that clicker off or that transponder off, then all of a sudden they call, hey, what do I need to do? Can I work out a payment plan? Please turn my clicker back on. One person called and complained every day because his teenage daughter was driving him nuts because she didn't like talking to the guard every day. So that can be an effective tool, and that is if they are 90 days delinquent. So keep that in mind. Again, you can't keep them out altogether. You can't stop them from parking, but you can turn off the clicker and then tell them they can't use the clubhouse, they can't use the pool, they can't use the gym, those types of things. You would need to have a board meeting, because again, this is a board decision, and then send a notice to that owner, essentially letting them know that you've suspended their rights. That's the same process to suspend voting rights as well. So also there's an option for a covenant enforcement committee. And that is, you could have a committee essentially the same as your fining committee, but here, instead of fining, they ultimately decide to suspend use rights based on violations or the history of failing to comply with governing documents. And it would have to be for a reasonable period of time. You can't tell someone they can't use the pool forever and ever and ever. It needs to be reasonable. All right, we'll get into collections. Now, this is what we always say is the most powerful tool that the association has in its arsenal. Now, before I get into, let me get into the basics, and then I'll tell you about the new changes in the law that are not going to be fun. So the association has the power to levy assessments against individual parcels, and this is related to the expenses that the association needs to operate and maintain common areas and to carry out, its powers and duties and to function properly. Now, you have to look at your declaration in terms of how you're assessing your owners. Typically for an HOA, it's probably, a flat number across the board. Everyone pays X every month or every quarter or every year. Condominiums, sometimes there's a difference. So you may have it if you're in a townhome or villa or something. If you're a, type A unit, you might pay X, and a type B unit might pay Y. That would be broken down in your declaration. Assessments that are not paid when they're due bear interest. You have to look at your declaration. Your declaration may actually have a lower number. If it's older, it may say that your interest rate is no more than 10%, or I've seen 6%. Now, if you don't have that, the law actually lets you go up to 18%. So that's another one where we say, you might be leaving money on the table if you have old language in your declaration. You would want to amend that and basically put in an amendment that says at the highest rate allowable by law, and then you could charge 18% interest. Late fees, they can't exceed the greater of $25 or 5% of the amount of each installment. Same thing, it has to be in your governing documents in order to do it, or you have to have the authority in your governing documents to do that. So look at your governing documents for that as well, so you don't leave money on the table again. The association can collect attorney's fees and costs incurred with collection, with the whole collections process. So that's good to know. Essentially, the owner is going to be paying for those things. Now, before we get into these letters, this is where I wanted to bring this up. Now, there was a change in the statute this year, effective July 1st. Now there is a new requirement for collections, and this is a notice of late assessment. And I will read this provision off for you. The association may not require payment of attorney's fees related to a past due assessment without first delivering a written notice of late assessment to the owner, which specifies the amount owed to the association and provides the owner an opportunity to pay the amount owed without the assessment of attorney's fees. So And then you can't pursue collections for the 30-day period of this notice. So you have to send this notice. This is a new requirement as of July 1st, 2020. You have to do this, and condos have to do it too. And it's a big pain, and we are not happy that this happened, but here we are. So we're dealing with it. Before you can turn a file over to our office for collections, before we can do anything, because obviously we would charge attorney's fees to do anything on that file. Before you can think about charging an attorney fee to an owner, you have to send this new statutorily required notice, a notice of late assessment is what they call it. And the statute lays out exactly what it should look like. It gives the owner 30 days to pay. You're not including any attorney's fees on it. It says this is the amount, this is the interest, these are the late fees. You have 30 days or we're pursuing collections. That has to be sent first class mail to the owner at his last address as reflected in the records, and to the parcel address if that's different. So make sure you are very careful about this, because again, this is a new thing and we don't want people to screw this up because it's going to delay your collections. And you also have to have an affidavit of mailing proving that you did that together with that notice of late assessment. So if you are going to try and turn a file over to us for collections, our first response back to you is going to be, hey, did you send a notice of late assessment? And do you have an affidavit showing you sent that notice of late assessment? So keep that in mind. This is new, hot off the presses as of July 1st. This is now a lovely, annoying new step that we have to deal with. So that's going to be your step one. So you have to send that notice out. Now, let's say you've done it. Great. You send a turnover to our office, and you've sent the notice. You've done everything you're supposed to do. And now we can proceed. Now, this is how we get into now what our firm would be doing for you. You have to, and actually let me back it up. In addition to just that notice of late assessment, you may have a policy or a procedure in place where your management company sends a little reminder, a late notice, hey, one sort of reminder, and then maybe another reminder. And now maybe this notice of late assessment really throws off your plan. But now you have to maybe you do a reminder, I don't know, when you would normally turn it over, a couple months that it's late, that they haven't paid. Then you send this notice of late assessment. That's another 30-day window we're tacking on. So maybe you turn it over to the attorneys, you're already, I don't know, 3 or 4 months delinquent, or this owner's already 3 or 4 months delinquent, and now you turn it over to us. The first thing we have to do is send another notice. Before we can record a claim of lien against the property, we have to send another notice to the owner. We have to give them 45 days to pay, factor in a couple days for mailing as well. Then we let them know, hey, we're going to record this claim of lien. If you don't pay, they don't pay. We say, okay, now we're recording the claim of lien and we're going to foreclose if you don't pay in this next 45-day period. So we have a 90-day window that we have to comply with our two statutorily required notices. Now that's in addition to the 30-day notice you guys had, and however long you took before you sent them a late fee or whatever. So you might be, and that's before we can go to foreclosure. So an owner could be 6 months, 7 months delinquent at that point. From the time they stopped paying to the time the file gets to foreclosure, you could be 6 or 7 months down the road. So keep in mind, and that could be significant, really. Keep in mind, you may want to have an aggressive collection policy, talk to your attorneys, maybe consider adopting a policy that it's, if a file's 45 days late or 30 days late, we're sending that notice of late assessment. We're getting the clock ticking on that 30 days, and then we turn it over to the attorneys. So at least you don't have that delay. Now, special assessments. Oh, the other thing to keep in mind too, and that's outlined in here, there is a application of payments that's outlined in the statute. If someone does make a payment, that payment is first applied to the interest, then to the late fees, then to the costs, then to the attorney's fees. Last, it goes to the delinquent assessment. So that zero balance may take a while to get paid off if you're only making partial payments. It doesn't move your delinquency date, up, if you will. Special assessments. Now look at your governing docs, see if you have any unusual language in there in terms of special assessments, but typically a special assessment is adopted in the same manner. It's treated in the same manner as a regular assessment, really. It's adopted at a 14-day notice. This is the other exception. 14-day notice for a board meeting at which the special assessment is going to be considered. You have to have on the agenda what that, what the a statement of what that special assessment is going to be for, the nature of the assessment and the estimated cost of the assessment in order for your special assessment to be valid. So now that could just be for an unexpected expense, maybe operating, your budget just was short this year, you had more expenses than you thought and you need to make up for it. Or maybe it was something where, hey, we didn't think we'd have to replace this pipe and we do, and now we need an extra, $20,000 this year. That's essentially what your special assessment is going to be for. And that is adopted by the board typically, not the membership, at a 14-day meeting, 14-day notice meeting. And that meeting has to have, the notice of the meeting has to have the statement of the special assessment, the nature, the cost, all of that. Let's see. And then if it's not paid, and really it's up to the board in terms of how they want it to be adopted. If you're going to adopt a special assessment that's, pretty large, maybe you do it over time, maybe it's installments, maybe it's due all at once, but you can allow payments over time if they opt in or something like that. Again, if you're going to have a larger special assessment, talk to your attorneys about the best way to schedule it for your community. If a special assessment is not paid by the due date, it's treated again, same way as a regular assessment. It can still become the subject of a lien, can still be the reason that you foreclose on someone's property just because of the special assessment, same thing, treated the same way as regular assessment. Now, conducting association meetings, the big question here is what type of meeting, and the way you figure that out is who's voting. That's the big question. So membership meetings for HOAs, typically your membership meeting, there's usually only one a year. It's your annual meeting. Now, you look at your governing documents. You could also have special meetings if you were considering maybe adopting an amendment or doing something else. There might be a reason to call a special meeting, but typically for membership meetings where members would be voting for HOAs, typically it's just the annual meeting each year. Now, the notice of your special membership meeting, look at your governing documents, look at your bylaws. It's probably 14 days, but look at your bylaws and confirm. You're going to have to do an affidavit, making sure you've mailed that properly. You have an agenda. Now, quorum is an interesting one. Quorum, unless you have a lower number in your bylaws. So unless you have a lower number, your quorum requirement is going to be 30% of your total voting interests. Most documents, go back to the dawn of time, and they probably have something like a majority, 75%, 2/3. And realistically, we realized it's just too hard to get that. And then you'd never have quorum and you would never be able to conduct a meeting. So luckily, legislature kicked in, said it's 30% of your total voting interest unless you have a lower number. So you could have had, more modern documents, or you could have amended your governing documents to maybe say 20% is going to be our quorum requirement, or 15% is going to be our quorum requirement. But odds are it's 30%, unless again, you have something lower. And quorum is just essentially, it's the number you need in order to conduct business. Everyone has the right to speak at the meetings. The owners have the right to attend the meetings. You can adopt some reasonable rules to try and keep things in order regarding how you're going to conduct the meeting. Voting, members have the right to vote in person or by proxy. This is different than condominiums. In condominium world, if you have an election, they have a whole process. It involves envelopes, multiple notices, all of that. They cannot vote by proxy in their election. For HOAs, unless you have certain language in your, or special language in your governing documents, typically you can vote in person or by proxy. So you could give someone your proxy and let them, attend the meeting for you and vote for you. Now, if you don't have quorum at your annual meeting, there's no election because you can't conduct business. So then your board just rolls over and the same people stay on the board. Now, I know, because we get this question a lot, we get complaints, if you will, where people say, hey, you know, we've had the same board for years, and we never have an election. Well, it's probably because you haven't had quorum. So gather some proxies, try and get people involved. That's really all you can do. Board meetings of the board at which quorum of the members are present has to be open to all the owners. Now, this comes up a lot where you hear people say, essentially, what does that really mean? What is a board meeting? A board meeting really is, so a quorum of the board gathered to conduct business of the association. So our position on that is, if you have, you know, a board of 5 and 3 board members just happen to run into each other by the pool, that is a quorum. But are they conducting association business, or are they just, you know, chit-chatting and, oh, the pool looks good. Oh yeah, the lawn guys are doing a great job. That's not really conducting business. If the 3 of them are sitting there and saying, hey, we should hire so-and-so. Did you guys look at that, you know, contract? What about this? Da, da, da. That's a different story. So conducting business in our minds really means voting, making decisions. You could maybe have a workshop type session where maybe only 3 of the 5 board members, or even all 5, want to meet with a vendor. Maybe they're, you know, meeting with the landscape architect to look at, you know, designs for the front gate or the front entryway. Is that a board meeting? If they're not making any decisions, but they're just meeting with him to get his proposal, probably not. I would say make sure you properly notice a board meeting and discuss those issues at your properly noticed board meeting. Take the proposal back, discuss it in front of everybody, so there's no question. We're doing our open board meetings. Everyone can attend. Everyone can hear what we're saying. We're not trying to be, you know, we're not keeping any secrets. We're trying to be as transparent as possible here. Notice your meetings, make sure they're open. The only time meetings are not going to be open to the owners is if it's a meeting between the board and its attorney regarding proposed or pending litigation. That is an exception. That would be a closed board meeting, or a meeting of the board held for the purpose of discussing personnel matters. That is also going to be closed. We still suggest you notice that the meeting is happening, but it's not going to be open to the owners. Notice, like I said, typically 48 hours. There are the exceptions that we already went over. Owners have the right to speak. Let's see. All right. We'll get into amending the governing documents. The only thing I wanted to just comment on there is, again, there is a new provision, again, hot off the presses, July 1st, that if you are considering amending your governing documents and you're in an HOA, previously, you could adopt any type of restriction involving leasing, and once it's adopted, it goes into place and it applies to everybody across the board. Now that is a little different. There's a restriction in 718, which applies to condominiums. And now the legislature wanted 720 to have a similar restriction, if you will. So now, new language as of July 1st, if you are adopting an amendment that is going to restrict, and I'll read this to you guys. If it's enacted after July 1st, if it prohibits or regulates rental agreements, it will apply only to an owner who acquires title to a parcel after the effective date of the governing document or amendment, or to an owner who consents to that amendment. So if you are trying to prohibit or regulate rental agreements, now it's not going to apply to everybody across the board. And that is if you're considering amending your governing documents, because it has to be something that would come into effect after that July 1. Now, notwithstanding, they did allow for an exception. So if you want to amend your governing documents to prohibit or regulate rental agreements for a term of less than 6 months, and prohibit the rental of a parcel more than 3 times in a calendar year, those will apply to everybody across the board, those amendments in particular. So they did allow for those exceptions because we wanted to still allow people to prohibit short-term rentals, and essentially that was the compromise, if you will. So those types of amendments will apply to everybody. All right. Budget and reserves. Okay. So each year you guys have to adopt a budget. Hopefully management helps you out with that. The budget should typically just be, it's considered a good faith estimate. Look at last year's budget, and then odds are you probably, at this rate, you're probably bumping everything up. Let's be realistic here. I know cost of everything seems to be going up, but you know, there may be something you can reduce. Maybe you had a big lawsuit last year, more attorney's fees than you think you're going to need this year. You could alter that accordingly. The budget has to have your estimated common operating expense on an annual basis. It has to have the beginning and ending dates. It has to show the total assessments to be paid by each parcel. And then fees and charges paid for any recreational amenities. And then also capital expenditures, deferred maintenance. And we'll get into that in another minute. But two things that your budget really has. Essentially, it's your operating, that's your day-to-day stuff. And then your reserves. That's going to be those are your two categories, if you will. So operating expenses, like I said, that's your day-to-day stuff. You know, paying your lawyers, paying the landscape guy, paying all of that. So admin, management fees. Now reserves. So part 2 of your budget. This gets a little bit tricky. So statutory reserves, that's the big thing here. What are reserves? When are they included? What is it really? What counts as a reserve? Your proposed budget has to include statutory reserves for capital expenditures and deferred maintenance if, and this is big if, so only in these 2 instances, if they were initially established by the developer or they were established by the membership upon an affirmative vote of a majority of the total voting interests. That makes them statutory reserves if it's one of those 2 options. If it is not, then it's not a statutory reserve. So if somewhere along the line, a board decided, hey, let's set up this reserve account, it might not be a statutory reserve. It might just be a rainy day fund that they've just called a reserve. So try and keep those clear. Deferred maintenance is typically maintenance repair that's going to be performed less frequently than yearly. Capital expenditure, you know, an asset whose useful life is greater than a year. Pavement, that's the big example, resurfacing, sidewalks, maybe roof of your clubhouse, things like that are going to fall into those categories. So reserves established by the developer, you look at your governing documents, that's how you'll know if they were established by the developer or not. And essentially, if the developer requires that there are going to be reserve accounts, then there you go. Now you have them, they're in your governing documents. So you have to fund those, or those are considered your statutory reserve accounts. Now, if it was established by a membership vote, let's see, then it's an affirmative approval of a majority of the total voting interest. And again, there should be a record of this. So minutes at some point, the voting records, then that's how you would know, because it has to happen at a meeting of the members or by written consent. So you would have some record that this is what happened to figure out if reserves are statutory or not. Now, like I said, if the board just uses the term reserves, they may not actually be statutory reserves. It may have just been a rainy day fund, an extra fund, something like that. We say, you know, if you're going to add, or if the board is considering establishing a reserve account like that, don't call it a reserve account if it's not a statutory reserve. Call it something else, contingency fund. Again, rainy day fund, whatever you want to call it there. Computing reserves, and again, I saw in here that I think Association Reserves was one of the companies that Terry had on that opening screen there. They can help you out with this for sure. But essentially, you can talk to a company that will compute the reserves for you, or there is a formula here that they would follow, but you might want to have a reserve study done by the experts there to get your reserve numbers. Pooled reserves. Do you have pooled reserves or straight line reserves? Sorry, I'm losing my spot here in my outline. If you're considering waiving or partially funding reserves, so if these are reserves, like we said, that were established by the developer or established by the membership, if you're supposed to have statutory reserves, then to not include them in your budget, then you should have a vote of the owners to either waive them or partially fund them if you want to, you know, not fully waive them. So to waive or partially fund those reserve accounts, you need a vote of the membership. And that would be only for applicable to the year that they vote for. The vote, whether or not to present the vote is up to the board. The board might want to fund those reserves, and that's fine too. They don't have to present that vote if they don't want to. If you want to use reserves for another purpose, you also need a membership vote. So if you had a reserve fund that was established by the developer that was supposed to be for paving, and you have those funds and you're sitting there and you need to do that roof clubhouse, or you need to waterproof the clubhouse and you want to use those funds, you can, the board can, as long as they get that vote of the membership. Now, terminating statutory reserves, you could terminate on the vote of a majority of the total voting interests, and then that would take them out of the budget. If you are, so this one here, reserves not established by statute, this is what I said before. If there is essentially, if you have something that says funding reserve accounts, but it wasn't established by the developer or by the members, so maybe it was a voluntary account or discretionary account, then like I said, we say call it a rainy day fund. And essentially it's going to be limited to, where is this? Hold on. So you have to look at that. If that's established by the board, that's treated differently, and it's not the definition of reserves. So look at that carefully. And like I said, call it something else, discretionary, emergency, contingency fund, something like that. Now, adopting your budget for an HOA, check your governing documents, check the bylaws. There might be a requirement in terms of the notice needed to adopt your budget. Typically, though, there isn't. So usually an HOA is able to, the association or the board is able to adopt the association's budget at just a regular old board meeting, which is 48-hour notice. And the agenda item should just say consideration and adoption of the association budget. Now, you might want to, again, check your bylaws, because you might have a different requirement. It might be 14 days. It might be some other advance notice. But if your documents are silent, 48-hour notice is all you need. And then also, you may or may not have to actually provide a copy. You may want to, but unless you're required to by your governing documents, statute doesn't make you do it. So keep that in mind as well. Financial reporting. Now, this is the report that essentially goes to your owners, gives them an idea of what's going on, how the association's doing. Each year, the board has to prepare and complete a financial report. Obviously, a third party could do it, the accountants, whoever else. There's a deadline within 21 days after your financial report's completed, no later than 120 days after the end of the fiscal year, or a date provided in your bylaws if there's something different. The board has to provide a copy of this financial report or written notice that a copy of the report is available at no charge to the members. So you could send the notice instead of the whole report. And if someone essentially says, hey, I want to see a copy, have to give it to them, no charge. By the way, I know it's after 5, but this is water, I promise. All right. The level of financial reporting. Now, if you have governing documents that talk about an audit and require an audit, you're stuck, you have to do an audit. Now, other than that, essentially your level of financial reporting is going to be based on your total annual revenue. So that's the number you want to look at, and then the statute outlines which level you're going to be in. So lowest level is the report of cash receipts. Then there's compiled financial statements, reviewed financial statements, and the highest level is that audited financial statements. So if you have to do an audit because your governing documents say so, then you're stuck with the audit. The only other way you'd have the audit is if your total annual revenue is $500,000 or more. Now, you can raise the level of financial reporting. So if the board wanted to up the level of financial reporting, then they could do that. Now, if they wanted to go down a level, that's a different story. Now, if you think about it, this makes sense because owners want to know where their money is. So if the board suddenly wants to reduce that level of financial reporting, it might raise some red flags. So you would actually need membership approval if you wanted to decrease the level of financial reporting. If you want to increase it, the board can do that on their own. Let's see. Now, reserves and disclosures. There are certain disclosures you have to put in there. If you don't have statutory reserves, there's a whole blurb there that basically says, hey, we might have to adopt a special assessment because we don't have statutory reserves. If you have reserves, but they're not, or if you don't have statutory reserves, but you have some sort of like rainy day fund, extra reserve accounts, then there's a slightly different blurb there. And again, we won't read it, but it's all in there for you. Government filings, the only ones we really care about for the most part, check with your accountant. Even though you're a not-for-profit, you might have income tax. You might have actual income to report. Maybe you did an agreement with Hotwire or, Comcast, and you guys actually got a payout and you get some money from that agreement. Check with your accountant, see if you have to file for your income. Also, you have to file, you have to be registered with Division of Corporation. That's that sunbiz.org where you guys are listed. If you don't file in time, then they charge you a late fee, but that's fine. Now, another thing that I like to mention here, even though it's not in our outline, and I don't want to go down a whole road with it, but Marketable Record Title Act was something that came up some years ago. And essentially it's part of 720, but it's also in chapter 712 of Florida statutes, where essentially your covenants will expire. Potentially your covenants might expire after 30 years from the root of title, which is typically when your deck is recorded, but not always. It would depend on the individual lots and all of that. So the board has to preserve the declaration of covenants, because those are your covenants, has to preserve your declaration if you're within 30 years of when it was recorded. So it's a pretty simple process if you're in that window. If you're outside that window and you've already missed the deadline, it's a much more complicated process. You need to get a membership vote and it turns into a whole thing. But if you're within that 30-year window, it's a fairly simple process. Talk to your attorneys, check when your governing documents were recorded and make sure that you've preserved them if you're within that time, or talk to your attorneys about getting that done. And that's only HOAs, that's not condominium, just so you know. Record keeping, owner access to records. Okay. Now, association has to keep certain records, as you know. Now, these are copies of your governing documents, all of your rules, minutes, all of that. Now, they've just clarified that copies of ballots, proxies, things like that are going to be kept as part of the records too, even though they weren't outlined specifically in the statute. Official records have to be kept for at least 7 years. There is an exception. If it's a certificate that you get basically because of tonight, then that's only 5 years, or as long as you're on the board uninterrupted. Now, owner access to records, and this is where records inspections come into play. And hopefully, again, your manager probably deals with this headache more than the board members do, but you may have owners who become, a little annoying because they want to inspect the records. They have the right to do that. Statute says they can. Great. We're not keeping any secrets. Fine. They can see the records. Now, you only have to give them access to the records. It does not mean if they send you, a letter and they say, we want to see the minutes of, this from this meeting, then we want to see the minutes of this meeting, and then we want to see the minutes of, this meeting from 3 years ago, and then this one from 4 years ago. You don't have to call through all of your records and pull out everything that they want to see. You just have to give them access to those records in the manner in which they're kept. So if you have a file of all minutes, they can look through that file. You don't have to pull out each one that they've referenced. Now, it's important to note you have to make the records available within 45 miles of the community. So make sure you're within that distance. You have to respond within 10 business days and make them available within the 10 business days. If you get a request by certified mail, return receipt requested. So, and now that's a rebuttable presumption. If you don't make them available within that time, there's a rebuttable presumption of a willful failure to comply. And then you're subject to possible damages, $50 per calendar day, up to 10 days plus attorney's fees. So if you get something that looks like a records inspection request, send it over to your attorneys, make sure you start making arrangements to respond and essentially say, hey, okay, we'll make them available to you. You can come to the management office on this day, this time. And if that doesn't work for them, then you can always coordinate and then you could do it beyond the 10 days. But we would recommend give them an appointment at least within that 10 business days. Now, you could also, the other option is you can have all of your documents if you happen to be, super high tech and all of your documents are scanned in or on a hard drive or something like that. You could send them to them in an electronic format. They could come in and look at them on an electronic format, and then they could just print them, as they wish. You can adopt reasonable rules regarding the frequency, time, location, and manner of inspection. So if someone keeps, sending you requests and it's starting to get a little annoying and you have to keep making these appointments and all of that, maybe talk to your attorneys about how you can adopt some rules and sort of bring that down a little bit. You can charge up to 25 cents per page for a copy made on the association's copier. If you don't have a copier available, then you can send it out, and essentially then you can charge for what that cost is going to be. You can also charge the cost required for the personnel if the time spent exceeds 1/2 an hour, and your cost is not going to go beyond $20 an hour. So it's not meant to be a moneymaker. Just keep that in mind. You can't stop someone if they want to, instead of actually making a copy, if they just bring their phone and they want to take a picture of it. Can't stop them if they have a personal scanner. That's fine. Can't charge them for that. Obviously, that's their own thing. Can't charge them for that. There are going to be certain records that are still official records. So you have to have them and you have to maintain them, but they are not accessible to owners for inspection. So these are official records that are not open for inspection. So you keep them, but you keep them in the locked cabinet, or, the redacted area, if you will. So this is your records protected by attorney-client privilege, work product privilege, obviously anything that's pending litigation, that type of thing. Any information you have that you got in connection with the approval of a lease or sale or a transfer of a parcel. So if you run background checks, if you run, credit history, criminal history, if you have lease applications in your files, those all have to be kept in a separate area. Those are not open for inspection, but you have to hold on to them. And again, that makes sense because you don't want people going through, credit history and all of that sort of personal information. Or personnel records. Now, personnel records, this is tricky. So if you have a file on, maybe your maintenance guy or whatever, that's one thing, that's a personnel record. If you have a management company and you have a management contract, that's different. Your management contract is not a personnel record. That's different. The owners can see that. But if you have, a file on Joe, our manager, that's a personnel record. Now, I've gotten in this hypothetical a call from Joe where he has said, hey, everyone in the community suddenly knows how much money I make because one owner got the management contract and is, running their mouth that Joe makes X dollars a year. Why are we paying Joe X dollars a year? Well, and he said, anything you guys can do to stop that. Isn't that a personnel record? He shouldn't know that. It was in the management contract. Management contract is open for inspection. So nothing you could do about that. Medical records, if you have any medical records, which you might have if you've ever had, a request for maybe an emotional support animal or an assistance animal, you might have medical records of an owner. Social security numbers, driver's license numbers, if you're a 55 and over community, or a 55 or better, as some say, community, you should have copies of driver's licenses and social security numbers because you have to have surveys every 2 years of who's in your community. So if you have that information, keep that also in that sort of hidden cabinet, if you will. Phone numbers or email addresses. This is a hot topic. I know there are a lot of communities that publish directories. We say, okay, if you want to publish a directory, just let an owner opt out if they want to opt out. Here's that provision there. So essentially, we're going to publish your telephone number unless you tell us you don't want to be involved. Now, emails are a little different. If someone has given you the email address with the intent that that's how they want to get notices from the association, then that email address is now open for inspection. So keep that in mind. If you tell, if you essentially respond to the management company, hey, here's my email address, send all notices via email, that email address is going to be floating around in the official records. So, and that's open for inspection. And an owner might get that and then start sending you lots of email blasts and, flooding your inbox. Any electronic security measures, software systems, that's all kept closed as well. That's not open for inspection. Now, an important thing to know is the association is not liable for the disclosure of the information that, may ultimately get out. If an owner does, like I said, that example with finding out, Joe's salary, if an owner, even if the owner takes, a delinquency report and because he hates his neighbor, and he gets the delinquency report and goes, I knew it. I knew Bob wasn't paying his maintenance. Now I'm going to tell everyone Bob is a deadbeat and, you know, he's the worst. So they send out a flyer to everyone, or, you know, put a flyer in on everyone's car. Bob's the worst neighbor in the neighborhood. He hasn't paid his dues in, you know, 5 months. That's not between the association. The association has nothing to do with that. That's between, you know, this guy and Bob, essentially. You're not going to be liable if someone does, you know, improper things with the information they get from your records inspection request. Elections. All right, so we're changing a stream here a little bit. Now, elections for associations are a little different because typically, like I said before, if you don't have quorum, and that's going to be the big, you know, factor here. If you don't have quorum at your annual meeting, you're not having an election. For condominiums, it's very different. Again, there's an administrative code. The statute outlines how condominiums conduct their elections. They have a completely different process. HOAs, it's going to depend entirely on what your governing documents say. Statute doesn't really come into play here. Governing documents are going to control. Probably your bylaws, so look at your bylaws. Now, it's important to note, you know, the vacancy essentially is caused by the expiration of the term. You fill that vacancy at that election. Now, notice of the election is provided to the owners in the manner, again, as set forth in your bylaws. Otherwise, it's 14 days if there's nothing in there. The agenda, we say you should put it on there. A member can nominate him or herself as a candidate. Now, this is important. If you have a process essentially that lets owners throw their hat in the ring in advance, maybe you do some sort of election committee or nominating committee beforehand. And this is different. If it's a nominating committee that on their own picks, hey, we've got, you know, we think we have 3 good candidates for the board. We're going to give the board our 3 names that we came up with, and that's who we think should run for the board. That's one thing. It's a little different if the nominating committee or election committee or whatever you're going to call it takes names from everyone, takes volunteers, takes everyone who wants to throw their hat in the ring, their names in advance. And then if that's the case, great. Now anyone who wanted to run can throw their hat in the ring and can let everyone know that they want to be a candidate. If that's your process, then you don't have to allow nominations from the floor. If the process is like the other example I gave, where an election committee or a nominating committee only picks who they want, and it's not open for people to volunteer, or if you don't have any process like that in place, and we're just coming to the election and seeing what happens at the election, then you have to allow people to nominate themselves from the floor. So if you have a process where you can get nominated in advance, or you could nominate yourself in advance, you don't have to allow nominations from the floor. Otherwise, you have to allow nominations from the floor. Like I said, you could vote by proxy. That's very different again than the condominium world. So we've had, you know, owners who want to get on the board or who want to carry the vote, and they run around the community and they get as many proxies as they can. And they walk in with a stack of proxies and say, hey, I'm voting for 30 people tonight. I'm essentially going to carry the vote, or I'm going to, you know, I'm going to name the whole new board. That is one way to do it. You could do it that way. Look at your governing documents. Sometimes there's limits on how many proxies somebody could hold, but typically, in theory, that could be done. Quorum has to be established, like I said, so we're circling back. Your lower number, if you have a lower number, it's going to be that. Otherwise, it's 30% of the total voting interest is your quorum requirement. You need to have the 30%, or you're not having quorum, you're not having an annual meeting, you're not having an election, and the board just rolls over. Eligibility. All members are going to be eligible to serve unless they're otherwise disqualified. Now that means essentially, if they're convicted of a felony, they're not eligible to serve unless their rights have been restored for at least 5 years. A person who's more than 90 days delinquent is ineligible to serve. If you are on the board and you get to be over, 90 days or more late, technically you're supposed to be removed. So make sure if you're on the board, you stay current. Now, a director or officer, and I'll read this because it gets a little tricky here, who is charged by information or indictment with a felony theft or embezzlement charge that involves association funds or association property is going to be removed from office. what's interesting there is it's a charge or an indictment. So there's no actual conviction required. When they are removed, that vacancy can be filled by the board till the end of that period, till they come back, or till the end of the term, whichever happens first. Now, if the charge is ultimately resolved with a finding of guilt or an acceptance of a plea of guilty or no contest, or sorry, without a finding of guilt, I don't think I said that right, without a finding of guilt or a guilty plea or a no contest plea, then that person can be reinstated for the rest of their term. So if it was, a charge and then the authorities looked into it further and everything got dropped, everything was, it was all a big mistake, the person can be put back on the board. If they have the charges are still pending, then no, then they're off and they can't be appointed. Now look at your bylaws in terms of how long, what your term is going to be. Typically it's a 1-year term, but you may have, some communities have staggered boards. Some communities will have 2-year terms, 3-year terms, or, where they rotate. So then they elect, half the board this year, half the board next year to keep some consistency, and they serve 2-year terms. Your certification requirement, that's why we're all here, right? So within 90 days after being elected or appointed, a newly appointed or elected director has to certify in writing that he or she has read the governing documents and the rules of the association and will work to faithfully uphold the documents and policies to the best of their ability and discharge his or her fiduciary duty. It's like a Scout's honor type thing. I read the documents. I'm going to do my best. I'm going to exercise my fiduciary responsibility. The end, and you sign a certificate. Or that's one option. Or within the 90 days, you submit a certificate that you did an educational course that was administered by a division approved education provider within 1 year before or 90 days after the date of election or appointment. So that's this. Yay. If you are taking a course, if you're here tonight, this is a division approved educational course. This is your board certification course. You could be taking this anytime within 90 days after being elected or appointed, or within a whole year before you get on the board, and that certificate's going to be good. We suggest obviously you take the course as opposed to just signing off on the certificate, but maybe you have a time crunch, maybe your 90 days is coming up and you wanted to sign the certificate. Okay. Now, either way it works. Like I said, they're valid. It doesn't have to be resubmitted if you stay on the board without interruption. If a director does not file the written certificate, they are suspended from the board until they comply. So if it's 91 days after someone got on the board and they have not filed the certificate, either saying, I read the docs and I'm going to do my best, or have taken the course and gotten a certificate that way, if they've done neither of those things and we're on, day 91, they are technically suspended from the board. They'll jump right back on as soon as they comply. So, it's a pretty easy fix, but still make sure everybody's complying and get them certified. Technically, the board can fill the vacancy temporarily. So, and also if you vote during that time, it doesn't affect any decisions the board has made. Certificate has to be kept as part of your official records for 5 years. Like I said, vacancy. Now, if a vacancy occurs on the board, because somebody resigned, somebody, God forbid, passes away, somebody doesn't want to be on the board, they move, they sell their lot, whatever it is, look at your bylaws. But typically, a majority of the remaining directors is just going to be able to name that replacement. There may be funky language. Sometimes we've seen that where you have to have an election or the members get to, weigh in on who the next person's going to be. But typically, the remainder of the board members, they get to pick and appoint the nominee. Now, or the appointee. Now, something to keep in mind is going to be a question of where your terms are. Again, usually you fill the seat and then you stay on for however long that term was. But look at your governing documents, because if you have staggered boards, maybe they have 2-year terms, there might be some language in there that says they stay on until the next annual meeting, as opposed to throughout the term. So if you were, if it was a 2-year term and you were only 2 months in, and Sally steps down and you put Mary in her spot, does Mary get to fill out the next 22 months, or does Mary have to, at the next annual meeting, are we having an election for Mary's seat? So take a look at your governing docs so you can figure that out. Typically it's just till it's the remainder of the term. Election disputes. Let's see, we'll go through this. Recall, I don't want to get into this too much. Essentially, it's very complicated. There have been a lot of changes lately. If you want to recall somebody from your board, basically that is the only way to get someone off the board. Sorry, I know, don't shoot me, don't shoot the messenger. If you were going to come and say, hey, that guy Bob is on our board, he doesn't listen, or maybe he never comes to meetings, he doesn't do anything, we want him off the board, we want to replace him, we think he's useless, he's terrible, whatever else you're going to say, I'm going to tell you the only way to get him off the board is wait till the next meeting or the next annual election, or you have to recall him if he won't voluntarily step down. And that's really the only way to get someone off the board altogether. If you want to change officer positions, that's different. The board can do that at a duly noticed meeting, and that's a board decision. Maybe you have somebody who, volunteered to be the secretary, but actually misses a bunch of meetings, hates taking notes. Nobody can read their handwriting. And you think they shouldn't be the secretary anymore. We want, someone else to do it. You could do that. You can reorganize, is what we call that, change the officer positions. That can be done in a board meeting. But to get someone off the board, you have to go through the recall process. And again, it's complicated. If you're looking to recall, talk to your attorneys before you do that. I don't want you to waste your time. Oh, here's a new interesting thing too. Electronic voting. This is now a hot topic. This was new a couple years ago, probably more than a couple now, but I've lost all sense of time. So in the last year or so, electronic voting has probably gotten a lot more popular because electronic everything. Hi, we're via Zoom. This is weird. Normally, I'm in a room full of people and I get to hear you guys laugh when I crack jokes, but here we are, new world. So the association could do its election and can also have owner votes through an online system. It has to comply with certain restrictions or certain requirements. So you'd have to get the proper entity to do this for you. You need a third-party vendor essentially to run this for you, but it comes in very handy. We've seen it be very successful where maybe you do have a community where it's hard to get quorum or people don't show up for meetings. Or again, maybe you're in a global pandemic and people don't want to be in a clubhouse filled with, 100 other people. Maybe they'd rather vote from their computer or send a piece of paper in from their computer. Great. So electronic voting is something available to you. Again, becoming very popular now, which is nice. And again, it really helps if you're thinking about adopting amendments. If you, in addition to just the election, the amendments are really tricky because to get an amendment adopted, that usually happens at a membership meeting. Again, you need quorum to conduct business at a membership meeting. You need, again, the 30% or whatever your lower number is, if you happen to have one. Very hard to get in some communities. Some people just don't show up. They don't want to be involved. They don't really care. If things are going well, great, let the board keep doing what they're doing, but I'm not going to show up. So it's hard to get your amendments passed because you're not going to get people there. You're not going to get those amendments, no one's even going to get a chance to vote because no one shows up. So if you could do it by electronic voting, great. That saves everybody time. And usually also it may save some money in that ultimately the cost is not too bad. And then it saves in the mailing. So sometimes it sort of comes out in the wash. But to do it properly, you would have to have a method to authenticate the unit owner's identity. You have to, again, and it's all technical, there are a bunch of requirements, but essentially if you talk to a third-party vendor and they know what they're doing here, they should be able to follow the restrictions and talk to your attorneys, make sure they're doing it right. Contracts and bids. Okay. Now, a lot of communities we've seen lately, contracts and bids are going. Everybody's signing new contracts, everybody's doing work, which is great. It's good to see it. Hopefully it means, everybody's budget is pretty healthy. Now, sometimes it means it's because there's work that needs to be done and that's a little scary, but anyway, to get that work done, you're going to need to sign a contract. All of your written contracts should have in there the obligations of the parties, the cost of the services, frequency of the services being performed. If we're talking about landscaping or maybe, pool maintenance, are they going to cut the grass twice a month? Or is it every 2 weeks? Is it 3 times a month? All of those things should be outlined in there. We don't want anybody fighting, down the road. Hey, you said you do this. Well, it's not in the contract. So I don't know. Did they say it? Are they going to be bound to it? We all know, verbal contracts, yes, are binding, but realistically, if you can't prove it, if it's not on a piece of paper and you can't show a judge, hey, this is exactly what we agreed to, you're going to have a real tough time. So get everything in writing, get everything spelled out. And I'm also going to tell you, because I can't help it, I am an attorney, have your attorneys review your contracts. Don't sign a big contract for hundreds of thousands of dollars without your attorney looking at it. And then you come to us, 6 months later, hey, can you get us out of that contract? We don't like those guys anymore. Have us look at it before you sign it. And then we can make sure you're protected and make sure there is an out option if that's something you want to do. Prevailing party fees, that's something you might want to look at too. Like I said, termination provisions, you might want to be able to terminate. You might want to have a prevailing party fee if there's a dispute about the contract, and essentially you have to bring us in, or you have to bring in your association attorneys to help you out. You want to get those fees back from the other side if you're successful, but that's a double-edged sword. They could also, if the association is somehow, not prevailing in that case, you could be paying your contractor's attorney's fees in addition to your attorney's fees. So that's something to consider, and again, talk to your attorneys. Now, bids, this is an important one. We always get a question, hey, so we need 3 bids for everything, right? No, not quite. If the aggregate cost of the contract is more than 10% of your total annual budget, including your reserves, then you have to get competitive bids. And it doesn't actually say 3. That's always a good, guideline. 3 sounds good. You might have a lower or higher and somewhere in the middle, or, it just gives you sort of a good ballpark. But if you want to get 4 bids, great, why not? If you can only find 2 companies that are going to do that, okay, that's bids, plural. So 2 is okay. Now, you're not required to accept the lowest bid if prudent business judgment dictates otherwise. So in other words, if you had, 3 bids and the lowest one maybe for you guys doesn't quite sound right, or that middle one, you've done work with them before, or the neighboring community knows who they are and they've done work with them and you were happy with that and you've seen it, maybe you pick the middle bid instead of the lowest bid. And again, as long as that's something that a prudent business judgment would support. So basically, if a reasonable person would make that decision, you're fine, you're protected. If ultimately you pick that vendor, you could even pick the highest vendor, the highest bid. If you pick that highest bid because, hey, the neighbors used him for a similar project, we saw how that turned out, it was great. We've done our due diligence. They've been in business for 1,000,000 years. We've heard good things, all of these other, things that might lead you to say, so we're going with the highest bid. And then you use them, and then lo and behold, something happens. They're not doing a great job. The project falls apart, whatever it is. You're not going to be held responsible just because you made a bad decision, because it really wasn't a bad decision at the time. You didn't have that information. So you made a reasonable business decision, and unfortunately, it just went sideways on you. Now, if there's an emergency, or if there is a business entity that is the only supply, or the only source of this supply, then you don't need to get competitive bids. And I have seen this in the county. I've seen that once before. There was one very specific type of carpeting, and one vendor in Broward County had it, and that was the only vendor in Broward County that had it. So the association, and this was the condominium, but they couldn't get competitive bids because that was the only vendor that carried that one product. So there are exceptions. Now, let's see, there are some other exceptions in terms of when you have to get competitive bids. If it's, and I just use the shortcut, if it's a professional, then you don't need to get a competitive bid. So your attorneys, your accountants, your architects, those guys, and it's written out there, you're not going to need to get competitive bids for that. If it's a manager and it's made by competitive bid, you can actually have a management contract that goes up to 3 years if you do it by competitive bids. Contracts between the association and a director. Now, this is complicated, so we'll get into this a little bit. Now, ultimately, you may have, John Doe might be your vice president of the board, and he tells you, hey, guys, I own a landscaping company. John Doe's Landscaping. I can get the association the best deal in town. Why can't we, use my landscaping company? Now, okay, you see the conflict here because now John Doe's going to get a benefit here, but at the same time, well, but the association would get a benefit because he would give us a discount. So can we enter into an agreement with him? What do we think here, guys? So there is a provision in the statute that essentially says if there's a conflict like this where a director or an officer is going to be financially interested, you have to follow a certain procedure and it would be permissible. So that contract has to be disclosed to the board and it has to be entered into the minutes. There's going to be a vote. This is a slightly different vote. 2/3 of the directors have to approve going forward with this contract instead of the normal majority, 2/3. And then also that director would not be voting. And that contract has to be reasonable and fair to the association. And, again, as long as you sort of follow this process, members would have the authority to cancel the contract at the next membership meeting. But again, the odds of that happening, probably slim to none. Have to disclose it to them at the next meeting. And again, as long as you follow that process, you should be okay. But talk to your attorneys. This is where it got a little complicated, or this is one of those items that gets a little complicated in terms of conflict and possible financial benefits, if you will. In addition to the issue with the contracts, what about a director or an officer receiving a salary, receiving compensation? Is that allowed? You have to look at your governing documents. Essentially, you can't get paid unless there's something in your governing documents that authorizes it. Sometimes we've seen that there's a provision in the bylaws that says, an officer is compensated, maybe $50 a month for their time in service. But for the most part, odds are, sorry to be the bearer of bad news here for you guys, you're doing this out of the kindness of your own hearts and you're not getting paid for it. Just a voluntary, fun extra job, right? Now, you could be reimbursed for out-of-pocket expenses. If you have a meeting and, the copier goes down in the clubhouse and you need to run to Kinko's to make, 100 copies for the board, that's fine. You could be reimbursed for that. There might be something, insurance-wise, there might be insurance proceeds that you can be compensated or reimbursed for. Excessive gifts. You can't solicit as an officer or director or manager, can't solicit or offer to accept any good or service of value for which consideration has not been provided for your benefit, a member of your family, all of that. To propose or to provide goods or services to the association. So basically no kickbacks, that's not allowed. You can accept food to be consumed at a business meeting with a value of less than $25 per individual, or a service or good received in connection with trade fairs or education programs. So usually, like I said, normally we would have these courses in person, and typically we would have, little treats for you guys, cookies, fruit platter, cheese and crackers. But we joke that you don't get steak and lobster because we got to keep it under the $25 for you. Dispute resolution. So this is our last topic, and then we'll have a few minutes for questions. Like I said, there was a lot to cover today, guys. It's a 2-hour course, but it's 101, and we still get into a bunch of different topics. So we cover as much as we can. So disputes subject to pre-suit mediation. So let's say we'll bring it all the way back to when we first started, when we were talking about those trucks. So you have a covenant, you have a restriction in your declaration that says no trucks in the community. And you sent the guy a letter. He still has the truck. And again, we're not having an issue of any enforceability problem. You have it clear as day, not a problem. You've always enforced it. Everyone else listens, but this one guy won't stop parking his truck, won't stop, keeping the truck in the driveway overnight. You've fined him. He doesn't care. He's ignoring it. You've suspended his use rights. You've turned off his clicker. He can't vote. He doesn't care. He's ignoring it. You've sent him the letters. Doesn't care. Ignoring it. Still parking the truck in the driveway. So then we have boards come to us and say, well, we did everything we could. So I guess we're done. I guess he just gets to keep the truck in the driveway. No. There is one more step, guys. You can proceed with actual litigation and further legal action beyond those suspensions, beyond those letters. So we'll get into that. Now, if it's a dispute between the association and an owner, so again, in this example, the association and that truck owner guy, you would go to pre-suit mediation first before you file anything in court. And if that's a dispute, that's going to be if it's a dispute about, use of the parcels. So again, a violation, a typical violation, vehicle violations, something like that. Maybe about the meetings, access to records, covenant enforcements. So like I said, covenant enforcement, that's typically what we're talking about here. And that could be anything. That could be that they, painted their house, but they didn't get the architectural approval that they were supposed to get. Or they painted it a color that wasn't approved. Or, they've moved 10 new people in, but you have a lease restriction and they're not following that. Could be all of these things. Any of those types of violations probably going through this route. So you send a certain type of notice, which would come from probably your attorney. And I guess let me go through this. There are exceptions when a dispute's not going to go through pre-suit mediation. So if we're talking about collection of an assessment or to enforce a mediated settlement, that goes straight to court. You don't need to go through mediation. Also, if it's an eviction matter, you can go straight to court. If it's a breach of fiduciary duty, if it's about a recall, that doesn't go through this process. Now, if we're talking about, so let's say again, we have our hypothetical that it's a covenant violation. This person's parking the truck, they're not supposed to park in the driveway. And you come to us and you say, how do we stop it? How do we make them comply with the governing documents? So essentially, we would send a demand. First, we'd probably, again, send them maybe just a violation notice. Hey, you've already been given notices. Article 10 says no trucks. You're parking your truck. Please stop that. Please, find alternate parking for it. Otherwise, we're going down this path. So if they don't respond, you send them a certain notice. Now this is the pre-suit mediation notice, and the statute lays out exactly what it has to have in there. And essentially you send it, has to be sent certified mail to this owner, return receipt requested. You're offering to participate in pre-suit mediation. You're listing 5 mediators. So again, this is why it comes from your attorneys, 5 mediators who are going to help try and resolve the dispute. In this case, the association is sending it to that Mr. Smith with the truck. Mr. Smith now has to pick a mediator of the 5 we gave him and respond within 20 days. Now, the mediation is supposed to be scheduled at a mutually convenient date and time within 90 days of that written offer, unless the parties have agreed in writing to a longer time frame. We split the cost of the mediation. So the association's responsible for half, the owner's responsible for half. Now, mediators, keep in mind, are typically retired judges, attorneys, usually retired judges. So their hourly rates are pretty high, and they usually have a 2-hour, 3-hour minimum. But the whole thinking behind this was, if we can go to mediation and get everybody sort of at the table and see if we can hash out our problems there, we can get it resolved maybe without having to file a lawsuit. Great. Sounds great in theory. And sometimes that works. Sometimes finally the person, when they get, sort of the official looking paperwork, they show up at mediation and they say, fine, okay, I understand. I have to follow your rules. I'll keep, I'll put my truck in the drive, or I'll put my truck in the garage from now on. And maybe that's it, and done. Great. Now, if they don't respond, or they don't show up for mediation, or they don't pay, basically, if they don't cooperate with this whole process, then their punishment, if you will, if you go to court, and because now they haven't done mediation, so your next step would be to file a lawsuit. If you file the lawsuit, and let's say Mr. Smith, for whatever reason, happens to win, he's not entitled to his attorney's fees because he didn't participate in this first step of mediation that he was supposed to participate in. But the same thing could happen with the association. An owner could send a pre-suit mediation demand to the association, and the association might have to pick that mediator and respond and all of that. And so if you get something that looks like a pre-suit mediation demand, make sure you forward it to your attorneys and you deal with it right away. All right. And then as part of this, you can also be entitled to recovery of attorney's fees. If your settlement, if you are unable to reach a settlement in mediation, then the next step, like I said, you'd probably be filing a lawsuit. Your attorneys would file something maybe for injunctive relief, which typically means injunctive relief is, we're asking the court to tell this person to either stop doing something or to start doing something. So, tell Mr. Smith that our documents say he's in violation and he has to stop parking his truck in the driveway overnight. And hopefully your judge agrees with you and says, hey, Mr. Smith, stop parking the truck in the driveway overnight. And by the way, association, you're entitled to attorney's fees because you had to go through this whole process to enforce your governing documents. So, all right. 716, not bad. So let's go through some of these questions here. All right. And I know you guys have already sent the links. Great. Okay. Now, a couple different things we'll go over, and I'll try and sort of give you the cliff notes as we do this. And I'm not the most organized person with this, so I apologize. But someone's question is, if someone's on the board and they sell their home to a family member, but the board member continues to live in the home, is there any way for the board member to stay active and on the board? That may be. You may not actually have to be a record owner to be on the board. That would be something you'd look at your governing documents for. Would changing the roofs from tile to metal be a material change? Changing building color, alteration, or material change, could you clarify, please? Good question. So now, some years ago, there were questions about whether changing a paint color is a material alteration. And I'm going to tell you, we disagree with what the conclusion was, but ultimately the conclusion was that yes, changing paint color. So if you want to paint your building a different color, or your clubhouse a different color, that could be considered a material alteration. If it's, essentially the same color, but maybe they've stopped making the beige 101, A variation, and now it's really called beige 102, but it's substantially the same color, that might be a little different. So it's really going to be a specific question as to what we're talking about, and and talk to your attorneys about it, bottom line. Let's see. If there are two HOAs, a master and a sub, should the master have full power to dictate what happens in the sub? Okay, interesting question. So really, again, all of that is going to be established by your governing documents. You may have documents where the master is in charge of, maybe certain recreational areas or all of that, and they don't do much else. They don't really sort of get too involved with the sub community. But you might have a community where they do have a bunch of restrictions, and the sub doesn't really have a lot of its own restrictions because they just follow what the master says. It would all be what's in your governing documents. Let's see. All right. Our declaration is still in draft mode. Is it left up to interpretation? How are we able to get them amended? Not entirely sure what you mean it's in draft mode. Your declaration should be already in place and recorded if you're in a community that's already been established. If you're considering doing amendments, odds are your governing documents are going to require a vote of the members. If they don't specify, it would be a 2/3 vote. And then once they're approved, once you present them to the membership and the membership approves them, if you get that vote, now you record those amendments. So if it's an amended declaration or if it's amendments to the declaration, you record those, and now everyone's on notice that these are your new restrictions. Does the 14-day notice regarding rules adoption apply to condo associations? This is the HOA class, but yes. All right, now let's see. Does voting need to be done during compliance hearing? The hearing committee would decide at the hearing, yes. Let's see. Levying fines and holding compliance hearing, is there a time frame that need to be held after a violation is ignored by a homeowner? So typically we would suggest, maybe having a policy in place if it's a violation, and go through, maybe with your manager and how you guys want to do it and how the board wants to establish it. If you have a grievance committee, if you have a committee that maybe does inspections, if your manager does your inspections, maybe they go through the community, I don't know, once a month, once every 2 weeks. And maybe you've noticed the same violation, maybe they've reported back to the board, hey, there's been this violation, do you want me to send a notice? Hey, there's violation still there. We already sent the first notice. So should we send a second notice? Do we want to start fining now? Make sure you establish a policy that makes sense for your community. If you're how many notices or how many gentle reminders before you want to go ahead and start fining. There's nothing outlined in the statute, really. It would be however you guys decide. Let's see. If someone owns 2 homes and they're in violation for one, Can you suspend their pool rights for both? Yes, technically, I would say essentially, if it's based on a delinquency, their pool rights, yes, you can suspend their pool rights. Regarding restricting someone's access, when the resident has friends who allow them to take the fob or open the gate. I know, this is the problem. So realistically, yes, you can turn off someone's clicker, you can turn off their fob, you can turn off their key card, but also you're not security, you're not a police officer. You're not going to say, hey, Mr. Smith, I have your name on this list. You can't be in the pool right now. Get out of the pool. Be realistic here. You could turn his clicker off. You could turn that, again, the key fob off, but right. Mr. Smith might be friends with Mr. Jones and Mr. Jones might say, hey, let's go hang out in the pool. So sorry about that. Do amendments need the vote of the community? Can the board make amendments to the documents based on board votes? Okay, good question. This is going to depend. Sometimes you basically look at your governing documents first. Your articles, your bylaws might be able to be amended just by a board vote. We have seen that. But typically your declaration needs a membership vote. So the board would vote first and essentially say, hey, we want to amend X, Y, and Z. Let's have the attorneys put that together and put a proposed amendment together. And then you present it to the membership with the help of management, with the help of your attorneys. And sometimes there's a dual component. Maybe you need, a majority of the board, which you should anyway, and a majority of the owners, or maybe you need 2/3 of the board and 2/3 of the owners to approve that amendment. But the declaration is going to require a membership vote. Your articles and your bylaws, look at them first. They'll tell you how you need to amend them, but it might be just a board vote. Should the association send the intent to lien at a day 46, send the new statutory letter? So, okay, that statutory letter, that notice of late assessment, that has to go first before you're going to even look at attorney's fees. So before you go to the old statutory letter, the notice of intent to lien, and then the lien, those are going to come later. So do that notice of late assessment, and you have a 30-day sort of freeze. You send them that notice and you can't do anything within that 30 days while you're giving them a chance to pay. Then you would go to your other notices. Must there be both covenant enforcement committee and finding committee? That's up to the board, you may have that established in your governing documents. You may have essentially only one. You might just have a finding committee. Maybe you don't have a covenant enforcement committee. Look at your governing documents, probably up to the board. Let's see. All right. Emily said if we have not been enforcing restrictions or rules, we would need to send a notice out letting everyone know we're now going to start enforcing them. However, she didn't say there's a minimum time between when we send the notification and when we start enforcement. Is there a minimum time before we start enforcing the restrictions or rules? Good question. Sorry. So this is another one where there's really no hard and fast rule. It's not, you have to give them X number of days. It's just reasonable. So if you're going to, and that was part of that republication process we talked about. You want to be reasonable, send out your memo, say, hey, we haven't been enforcing, Article 10, but we're going to let you get grandfathered in. We're going to let you register your violation. So get that back to us, register your violation, if you will, by X date. And after X date, we're going to start to enforce. Now, again, I would say just be reasonable. Maybe 30 days is probably a good ballpark there. Let's see, who's responsible for sending delinquent account notices, HOA or management? That's up to you. If you have a management team, they probably do it. If you're self-managed, maybe you have accountants, maybe they do it. Maybe the board does it themselves, up to depends on how you're operating. All right. Let's see. Is the majority vote based on all members or those members that voted? Good question. So if you have 100 homes and 50 members voted, do you need 26 or 51 favorable votes? So going to depend on what vote we're talking about. You might have language that says an approval of a majority at a meeting at which quorum is obtained. So that would be, you have to get quorums, you got to get at least that 30%. And then a majority of those who vote would be what the vote that you need. Maybe that's for amendments. If we're talking about, just a straight up, if you need a majority vote, then a majority of all of the owners would be 50% plus one. So in that scenario, you would need 51 owners to approve whatever it is. But again, that language can be very tricky and you have to look at it very carefully and make sure you're getting the right vote, because we have had communities mix those up sometimes, and obviously the number can be very different. Let's see. What about Superior CDC or the other POA? Not sure what that question is, sorry. Would an attorney's interpretation of the documents be privileged? Interesting. If it's communication between the board and the attorney, it should be privileged. I like the commentary. Superb outline. Thanks. All right. Let's see. If the director took the orientation class to serve on another HOA board, can that certificate cover his service of a different board? That's interesting. I've never actually gotten that question before. But yes, I mean, really, it's a time period thing. You have to take the HOA, and now let me clarify this. It's an HOA course and a condo course. So if you take a condo course, it's not going to work if you're on the HOA board. But if you take, another HOA course because you were on a different HOA board, you're okay if it's within that 90-day window or a year before. I would say it would count for both HOAs, not HOA and condo. Let's see. All right. All right. Some other questions about fines. Let's see. Okay, this is another one procedurally that comes up a lot. If the board doesn't meet for several months, but bids and contracts need to be approved, could the board members approve via email and potentially ratify at the next board meeting? Could they ethically handle bids and contracts without having a properly noticed board meeting? Okay, be careful about this. You are not supposed to be voting via email. You're not supposed to be making decisions that way. However, as a practical matter, if, and again, COVID times, you could have a Zoom meeting, perhaps. So really, if it's a 48-hour notice and you're all over the place, set up a Zoom meeting maybe. But if for whatever reason, board can't get together, maybe you do have people traveling, maybe you have some snowbirds, maybe some people up in Canada, whatever it is, and you need to make this decision. The contractor needs this thing signed by, the end of the week, or prices go up because again, they're going up like crazy. So if that happens and the board essentially has to make that decision, you can make that decision, get a majority of the board to approve going forward. And then yes, at your next properly noticed, duly noticed board meeting, just ratify that decision. So you'd put on your agenda, ratify decision to approve contract with X vendor. All right. Another one. What's a good way to handle something that's not addressed in the docs or the docs are silent? And then the example given is gutters. And I'm assuming that this question is coming from someone who is in a villa community or townhome community, because then it's always a question of who takes care of the gutters and all of that. Could the board amend the rules to clarify or replace them as needed? Again, it's going to depend specifically on what the language is in your governing documents. Sometimes there's language that the board can essentially take on a maintenance responsibility that perhaps, then they could establish a policy that the association would pay for gutters. But that authority would be in your governing documents already, even if the documents don't actually specify anything about gutters. But if you wanted to establish clear as day, association is going to take care of gutters, or flip side, owners will take care of their own gutters, then that would be something I would suggest putting in an amendment and adopting it to your declaration. All right, Jeff, I know we're 7:30. I was trying to go through as many as I can.
Yeah. I just want, feel free to stay on and do a couple more. I know we have a bunch. I just want to let everybody know that if you do need to go, the part that gets you your certificate or your CAM credits, we have completed that. I'm not saying we would love for you to stay, but you don't need to be on for the Q&A if you have to run and jump, because we are at the advertised time. But Emily, feel free to answer as many as you would like. All
right, well, I'll give it a couple more minutes because I know there's some in here. Let's see, closed board meeting seeking legal counsel, do minutes need to be recorded? Interesting, because really with counsel, again, if it's a closed board meeting, we would suggest, posting it as still posting the notice that it's a closed board meeting, but indicating that it's closed because you're meeting with counsel to discuss pending or proposed litigation. Then really your minutes are going to be very generic. Essentially, here's who was in attendance, and we discussed pending or proposed litigation with the attorney. I wouldn't suggest putting much more in there because again, it's probably all going to be covered by attorney-client privilege at that point.
Does the
You're not
same
really
hold
making
true
any-
about closed meetings if it's like discussing the salary of staff?
Yes, so the other exception, it's the closed board meeting to discuss pending or proposed litigation with your attorney or personnel.
Okay.
So, right, so if you're discussing personnel issues, which sometimes that happens if you're, thinking of switching managers or you're gonna, fire the maintenance guy, and
Right.
you might not want to have that in an open meeting because obviously that can be a sensitive subject,
touchy,
if you
yeah.
will. Yeah. Do violations have to be backed by bylaws? Can board members submit a violation on anything they see fit? So this has been sort of an interesting topic lately too, where people think, kind of board members are coming up with violations or whatever it is. The violations should be coming from somewhere. There should be some authority, some language in your governing documents that, even, and it could be something sort of vague where it says, Article 3 says owners must maintain their lots in good and safe condition, like other, in the same manner as the other lots. And, the board wants to send a notice about, overgrown grass but you don't really specifically have a rule about how tall the grass should be. But if that's what you're sort of hinging your violation on, it should be okay. But yes, I understand people are concerned that some board members may take that authority and run with it, if you will. But you should have sort of a policy in place. I would recommend to the board, note which violations you're looking for. If you're working with a management team and they're doing inspections, let them know what they're looking for. Are we looking for, roofs that need to be pressure washed? New paint that maybe didn't go through the architectural review process, things like that. Give them a guideline of what they're looking for so they can let you know what violations they see in terms of what's based in your governing documents. Someone says they don't have the email with the outline. Jeff, is that in the chat?
It was in the chat, and also when anybody, just so you all know, glad you brought it up. When you leave, or when we end it, you'll get a window that pops up with a link. The link contains the evaluation, which you fill out for your certificates and your CAM credit. On that evaluation page, you will see. I'll show you this rather quickly here, so Emily can get back.
And
Okay,
then someone did ask, which this question sort of related, how often do we do the courses? Because there are board members that need to be doing this too.
Yeah.
So I don't know, do we have another date for our next one, Jeff?
At this point, I'm not certain. We're working on it. kbrlegal.com as well as tskmarketing.com, almost monthly now that we're getting back towards season. So the firm will likely almost have it monthly. To be announced rather soon. But if you're on our mailing lists on either organization, you'll be privy to it.
Okay. Someone asked, in the truck example, if the homeowner wants to keep parking his car and pay that fine, does the HOA have any other enforcement actions once the fine is paid? That's why I said sort of last ditch effort, you go the route of a pre-suit mediation and injunctive relief. It doesn't mean you're, once you've fined them, once you've suspended their use rights, once you've done that, you're out of options. And we do have a lot of HOAs that will say to me, well, we don't want to sue anybody. We don't really want to spend the money. We don't want to, go through all those steps. But again, you have a fiduciary duty to enforce those covenants and restrictions. So if you tried the fine, if you tried suspending, talk to your attorneys, because then you can go the route of the pre-suit mediation. Maybe that'll resolve it. Great. Or possibly filing injunctive relief, which is essentially a lawsuit, and getting involved in the litigation to enforce your governing documents.
Emily,
right.
could you speak 1 minute about the noticing the board meetings you were just talking about a minute before, between the 14-day board meeting, the 2-day board meeting, and the not noticing the board meetings at all?
Sure. So typically for board meetings, and now again, board meetings are where the board is voting, as opposed to membership meetings where membership
Right.
would be voting.
Right.
And that's, again, typically only annual meetings, sometimes special meetings, but typically annual meetings. Board member meetings, most of the time, you're going to be a 48-hour notice. The exceptions are, if you are considering adopting a rule that involves lot use, or if you're adopting a special assessment. And that's the big one, because that's the one that will come back to bite you if you don't properly notice it. Someone will inevitably not pay that special assessment, and you will try and turn it over for collections. And our office will say, hey, great, I need to see a copy of the notice. I want to see a copy of the minutes because we got to make sure it was adopted properly before we enforce this. And then we might look at it and say, well, wait a second, you didn't do a 14-day notice. So that could be an issue. So make sure you do that one properly. Now, in terms of not noticing a board meeting, all board meetings should be noticed, but there are some meetings that are closed, which means you're, in our opinion, is you still notice them, but you notice them as closed board meetings. So the owners aren't able to come to those. That would be two exceptions. If you're discussing pending or proposed litigation with your attorneys, or if you're discussing personnel issues. Other than that, a board meeting, and again, it's tricky to figure out what exactly is a board meeting, but a board meeting in our minds is when a quorum of the board is together and they're conducting association business. So they have to be doing something, voting, taking action, making motions. If they're, three board members that just ran into each other at the pool and they're chit-chatting about, back to school and the pool looks great and hasn't the weather been crazy, that's not a board meeting, even though there's a quorum of the board all in the same place at the same time. So it's dicey because I know one of the big complaints we always get is, I think the boards have secret meetings. They don't tell us what they're doing. We never know what's going on. And that may not be the case. Just be as transparent as you can, notice your meetings, and make your decisions in front of the members so you don't get that question. So that's our tip. On that, is there anything else we need to hit, guys, before we wrap up?
No, but before Terry mentions her parting words and with some of our service providers, I'm just going to place into the chat right now, since we'll be on for about another 60 seconds or so. For those of you who may have pop-ups disabled on your browsers for whatever reasons, I'm putting the link for the survey in the chat right now. So you can click on that link. If it's not clickable for you, copy and paste it into your address bars on your browsers and it'll get you there. Terry, it's yours. The floor is yours. Emily, thank you.
Thank you, guys, so much.
Thank you so much, Emily. This was a lot of information in a very short period of time. And we're going to try to get you up again because, like we say, our people really need it and they want it. So hopefully you'll come back and do this for us again soon.
Yeah.
Our service providers are great, and they are not up, Jeff. They are up.
There you go. They're also on the evaluation.
There we go.
Yes, there they are. So the evaluations are up there. And that's how you will get your credits from Kaye Bender. And aside from telling Emily what a great job she did, we're going to get you your credits. Click for the course outline right over there, and you'll be able to get it from there. And without any further information, are we leaving anything out, Jeff, before we go?
You did wonderfully. I want to thank you both. Terry, thanks for making this possible. Emily, thank you for joining us and helping bring these programs to our people that follow us and take our complimentary courses. We appreciate it. Thanks to Kaye Bender, Rembaum, and all of our providers for making these available to everybody at no charge. So please check them out at tskmarketing.com. Emily, how can people reach you and the firm?
Oh, good question. You can go to our website, kbrlegal.com. My email is just egannon@kbrlegal.com if you need me in particular for any reason. But check out the website. We have a lot of good information. If you're here, you probably get our email blasts. Make sure you actually read them, because we put in helpful information. When these new things were coming down the pipeline and these new changes, we were trying to send out blasts and put everybody, on alert, so you would know before that July 1st kicked in. So it's good. Stay on our email blast list.
Yeah, they put out great information, and we like to get it all the time. And thanks again, Jeff, for hosting, and we'll see everybody soon.